Hello, this is the Civil Liberties Section A, Role of Courts in Defining Rights lecture. Our prioritized standard is Government Civics number 16. Objectively, we're going to analyze the debate between judicial activism and judicial restraint as it pertains to judicial decisions. There is much debate as to what role the federal courts should have regarding the policymaking powers of the court. Judicial activism is the belief that the courts must correct injustices perpetrated or ignored by other branches of the government. As majorities impose their will, judicial activism can actually guarantee the rights of minority groups. And when we talk about minority groups legally, we're not always talking about ethnic minorities. Sometimes we are, but just any instance when you are not a part of the majority. Supporters of judicial activism would consider the Constitution to be a living document that changes as the country changes. Judicial restraint, this believes that the duty of courts is to ensure that the Constitution is enforced as it is written. With judicial restraint, courts should uphold acts of Congress and state legislatures unless in clear violation of the Constitution. Supporters of judicial restraint are concerned with the original intent of the Founding Fathers when deciding a case. So, for instance, if we looked at the Second Amendment, a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. So if you looked at that with judicial activism, you would probably say, okay, what does that mean today? And you might determine that today that means citizens have a right to own a weapon for self-defense. If someone looked at that with judicial restraint, you would think about what did the Founding Fathers mean by this? And the Founding Fathers, well, they were aiming for a well-regulated militia and basically saying as a part of a well-regulated militia, you have to be able to keep and bear arms. So if you were not a part of the militia, generally speaking, you probably wouldn't actually have a right to own firearms. The label of judicial activist is commonly given to a judge considered liberal or progressive, while the label judicial restraint is commonly given to a judge considered more conservative. So the left would probably be considered more of your judicial activist, as where the right is more of your judicial restraint. The claim of judicial activism is usually used negatively under the premise that the court has somehow overstepped its authority. Sometimes they might say that they are legislating from the bench and somehow violating the separation of powers. Critics claim that federal courts should merely interpret the law rather than make law, although supporters of judicial activism would say that it's just an aspect of judicial review. The Supreme Court's ruling in McCulloch v. Maryland of 1819 case likely opened the door to the concept of judicial activism. In the case, the question was if the government had powers other than those expressly given to it by Congress. More specifically, there's a couple questions. Could the federal government charter a bank? Which the Supreme Court said yes. And were state governments allowed to tax those government chartered banks? And the answer to that one was no. But a lot of times in Supreme Court rulings, they'll answer your question and then answer something you didn't entirely ask on top of that. So the court ruled in a 7-0 decision, if you love your margins, that the Constitution granted implied powers. More specifically, the necessary and proper clause of the Constitution granted implied powers, which we've mentioned that a couple times. In the recent history of the Supreme Court, there have been examples of both traditions. For instance, Earl Warren's court has often been cited as being activist. So he, of course, was the justice that expanded many civil rights and civil liberties and judicial power and federal power during the 1950s and 60s, responsible for ending racial segregation, also ending sanctioned voluntary prayer in public schools. As were William Rehnquist's court has been cited as reserving judicial restraint, overturning some of the precedents of the Warren court. So More specifically, Rehnquist's court has limited the power of the federal government and also increased the power of the states. Generally speaking, he would pretty much oppose rights that are not specifically listed in the Constitution as in overstepping. Now, if it is the duty of federal courts to show judicial activism or judicial restraint is an open question that's likely not to be resolved anytime soon. Moving on. The Supreme Court and the judiciary has an important role in the defining and securing of civil liberties, which are protections citizens have against government actions. Now, prior to the ratification of the 14th Amendment to the Constitution, the rights granted in the Bill of Rights actually applied only against the national government, not against the several state governments. So those Bill of Rights, originally that only protected you from the federal government, not actually state governments. The 14th Amendment's Due Process Clause actually states that no state can deprive any person of life, liberty, or property without due process of law. Because of the Due Process Clause, most, but you'll notice not all, of the Bill of Rights protections have actually been applied against the states. Now, those exceptions, for instance, the court has not incorporated or included the protections against quartering of troops. It's never actually came up. The right to a grand jury hasn't been resolved, or the right to a trial by jury in civil cases. That has not also come up either into the Due Process Clause. Now, if you take a look and try to see, hey, well, which is our newest Bill of Rights protection that we have against the states? Well, if you take a look up here, Second Amendment, that's only been a right at the state level since 2010. So that is actually a very new right. U.S. citizens are guaranteed many rights, but only as long as these rights do not infringe on the rights of others. All right, this concludes Civil Liberties, Section A, Role of Courts in Defining Rights lecture. Our prioritized standard again was Government Civics number 16, and objectively now you can analyze the debate between judicial activism and judicial restraint as it pertains to judicial decisions.